There's a power buried in UK law that allows a police officer to walk up to you at the roadside, take the cash out of your pocket, and simply drive off with it. No handcuffs, no caution, no charge sheet. You haven't been accused of a crime. You haven't been taken into custody. Your money is just gone. And the threshold that switches this power on isn't £50,000, or even 10. It's 1,000. That figure was fixed nearly 2 decades ago and hasn't moved since. Which means every year that passes, inflation quietly drags more and more ordinary people into its reach. Most viewers assume this only applies to obvious criminal money, bin bags stuffed with notes, suitcases full of drug proceeds. It doesn't. £1,000 is a used car bought privately, a rental deposit, a Saturday's takings at a market stall, or a tradesman who's been paid in cash and hasn't made it to the bank yet. And cash, as a legal term, covers far more than banknotes. I'll get to the official definition shortly, because it will genuinely surprise you. Here's the twist that trips almost everyone up: this isn't a criminal proceeding. Nobody has to prove you've broken any law. It operates under an entirely separate set of rules, and it's you who ends up standing in a courtroom trying to get your own money back. So in this video, what actually triggers a seizure, what an officer is legally obligated to tell you in the moment, the countdown clock that starts ticking the second your cash is taken, which works very differently than most people assume, how the money can eventually be returned, and the one careless sentence, said at the roadside, that has cost ordinary people their savings for good. I'm Adam King, and for years I've worked alongside criminal defence solicitors handling cases across England and Wales. This video reflects general legal information for that jurisdiction, not personalised legal advice, and it isn't a substitute for instructing your own solicitor. If your cash has already been seized, stop watching now and contact a solicitor immediately. Several of the deadlines discussed here are tight. Before pulling this law apart, let's be fair about it, because a lot of content on this subject leans dishonest for the sake of clicks. Criminal cash is a real phenomenon. It travels the country in gym bags and glove compartments precisely because it can't be paid into a bank account without questions being asked, and officers who intercept it are doing legitimate, valuable work. Most seizures aren't some kind of scam. This isn't a video claiming police are stealing from innocent people wholesale. It's a video for the innocent person who ends up in that exact roadside conversation, aimed at making sure they don't accidentally make their own situation worse, because the gap between cash that's returned within a couple of weeks and cash that vanishes for good is rarely about guilt. It comes down to what was said in that moment, and what could later be backed up with paperwork. The legal basis is Section 294 of the Proceeds of Crime Act 2002. Under it, a constable can seize cash where they have reasonable grounds to suspect it counts as recoverable property, meaning it either derives from unlawful conduct or is intended by someone for use in unlawful conduct. Sit with that wording for a second, because it's really the crux of the whole issue. Reasonable grounds to suspect. Not to know. Not to prove. Not beyond reasonable doubt. Suspicion, the same bar that lets an officer search you in the first place, now applied directly to your money. And this power isn't limited to police constables. The same section extends it to HMRC officers, serious fraud office investigators, and accredited financial investigators who may not be police officers at all. There's also a detail that catches people off guard. If an officer only suspects part of a sum, but separating it isn't practical, they're entitled to seize the entire amount. So £400 of suspect cash sitting in an envelope next to £2,000 of clean money means the full £2,400 goes with them. Now, that threshold. This is where people's assumptions are most out of date. The minimum figure is £1,000, set by statutory order back in 2006. Before that, it stood at £5,000. It was lowered, and it has never been raised again. Below that line, this particular power simply doesn't apply. At or above it, it does. And of course, £1,000 in 2006 bought a lot more than it does now. Because the number has stood still while prices haven't, the power effectively creeps further into everyday transactions every single year. Then there's the definition that surprises almost everybody. Under the official code of practice, cash isn't limited to notes and coins. It includes postal orders, checks of any kind, including traveller's checks, bankers' drafts, bearer bonds, and bearer shares, gaming vouchers, fixed value casino chips, and betting slips. So a check counts as cash under this power. So does a banker's draft. So does a pocket full of betting receipts. People often assume a piece of paper is beyond the reach of this law, and they're simply wrong. So what is an officer actually obliged to do while this is unfolding? More than most people expect, and this is exactly where your own record of events starts to matter. Before searching for cash under these powers, the Code of Practice requires the officer to give you their name or shoulder number and their police station, tell you there are reasonable grounds to suspect cash is present, and this is the key phrase, provide you with a clear explanation of those reasonable grounds. That's not a nicety, it's a written requirement. Ask for it in exactly those words and remember what you're told, because the justification given to you at the roadside is the justification that gets scrutinized later. They also have to explain which power they're relying on and what happens if you refuse to cooperate, produce any document authorizing the search, and give you the chance to hand the cash over voluntarily rather than be searched for it. There's also an approval requirement almost nobody's heard of, and it matters enormously if the case ever reaches court. Section 290 requires the officer to secure prior approval before using these search powers, unless doing so isn't practical in the circumstances. That approval has to come from either a magistrate or a senior officer. If it genuinely wasn't practical to obtain beforehand, the officer must report the search to a senior officer as soon as reasonably possible, and in any case, within 24 hours. You're also entitled to a written record of the search on the spot, unless that's impractical or would compromise an investigation. Ask for it. If you don't receive one that day, note the time and write it down. It's worth being specific about who this actually tends to happen to, because the mental image most people carry around is wrong, and that wrong picture is exactly what stops people from being prepared. It's the market trader driving home on Saturday evening with the day's earnings, the tradesman paid on completion who hasn't reached the bank yet, a family with an envelope of cash on their way to buy a car, plenty of older people who've never trusted banks since 2008 and keep savings at home. None of them look remotely suspicious to themselves, but every one of them can look exactly like a target at 11 at night in a lay-by with £2,000 in a bag. Because remember, the legal bar is only suspicion. Closing that gap between appearance and reality falls entirely on you, in the moment, under pressure. Which is precisely why preparation beats argument every time. Nobody wins this fight with a clever line at the roadside. You win it by being the person who can later produce a bank withdrawal slip. Now, the clock, and this is the single most misunderstood part of the entire process. Under Section 295, seized cash can initially be held for 48 hours, and that period specifically excludes weekends, bank holidays, and certain court holidays. So 48 hours doesn't mean 2 calendar days. Cash taken on a Friday afternoon doesn't need to be in front of a court by Sunday. Weekends don't count toward the clock. Throw in a bank holiday Monday, and your money can sit untouched for the best part of a week before a magistrate even looks at the case. After that initial window, if the authorities want to keep hold of it, they must apply to a magistrate's court. The court can grant that request, but not indefinitely. A first order can run for up to 6 months from the date it's made. Further extensions are possible, but the total can never exceed 2 years from the date of the very first order, and the law requires that anyone affected by such an order be given notice of it. 2 years is the absolute ceiling. Your money can be held that long without you ever being arrested, charged, or convicted of anything whatsoever. That's not a gap in the system. It's exactly how Parliament designed it. Before getting to how the money actually comes back, a quick practical note. If you're ever arrested, ask for the duty solicitor. It's free, it's your right, and hardly anyone requests it. And whatever happened during your stop, the body-worn camera footage and the officer's notes are your personal data. You're entitled to request them at no cost, and that request takes about 10 minutes to put together. Now, how the cash is returned. That route runs through Section 301, and it's worth knowing it exists because nobody hands you a leaflet explaining it. Anyone who claims ownership of the cash can apply to a magistrate's court to have it, or part of it, released to them. That's the sentence that actually gets your money back, and most people watching have never heard it before now. You are the one who has to apply, not the authorities. That's the shape of the entire process, and it's the part people find hardest to believe. They take your money on suspicion, and it's on you to go to court to reclaim it. The court is required to order its release once it's shown the cash belongs to you and what the legislation calls the release condition is satisfied, essentially, that the original grounds for holding it no longer stand. Which tells you exactly what the real argument is about. It isn't your character. It isn't whether you have a criminal record. It's where the money came from, provenance on paper, with dates that line up. That's the entire battlefield, and it's one you can prepare for well in advance. This is where this particular situation departs from most general legal advice. Normally, the safest instinct in dealing with police is to say as little as possible, because in a criminal matter, your own words are what create risk. An account that doesn't quite match your best guess becomes an inconsistency used against you. Here, it works differently. Here, the money itself is what's at stake, and total silence carries its own cost, because an unexplained pile of cash is, in practice, treated as the suspicion itself. Say nothing at all, and nothing contradicts the officer's working theory that the money is criminal, which means the file that eventually reaches a magistrate is thin, one-sided, and easy to act against. But giving an account doesn't mean having a full conversation at the roadside. You don't need to narrate your entire financial history standing in a lay-by. You need to do two things: assert that the money is yours, and commit to explaining it properly, in writing, afterward, some way you can actually be accurate. Claim ownership, promise the paperwork, then stop talking. That's the whole approach, and it's a genuine departure from the usual advice, because what's at risk here is different. Back to the roadside, because that's where cases are actually won or lost. The sentence that costs people their money is almost never a lie, it's a guess. Someone is nervous, wants to seem cooperative, can't recall the exact figure, and rounds it off. It's about $3,000, I've been saving it, when it's actually $3,400, some of which came from selling a motorbike back in March. Weeks later, the paperwork arrives and it doesn't match what was said at the roadside. Nobody writes down he was flustered. They write inconsistent account, and that inconsistency becomes exactly the justification needed to keep asking a court for more time to investigate. So here's the phrase, said calmly, once, it's mine, it's lawful, and I'll account for it in writing. That single sentence does three things simultaneously. It asserts ownership, which is precisely what Section 301 turns on. It admits nothing and denies nothing. And it shifts the real explanation from a roadside under pressure to a desk where you can check dates, gather receipts, and get it right the first time. While it's happening, ask for that clear explanation of the grounds, in those exact words. Ask for the search record. Get the officer's name or shoulder number and station. And that same night, before you go to bed, write down the time, the location, the amount, and everything you can remember being said. One line you should never cross, and here it matters more than usual. Saying little at the roadside is entirely lawful. Explaining yourself properly afterward is sensible, and it's what actually wins these cases. But lying about where the money came from is a criminal offence in its own right, and submitting paperwork that isn't genuine turns a civil dispute you were probably winning into a criminal case you won't. The winning approach was always the boring one: bank statements, an invoice, a receipt for the car, a message from a buyer. Dull, dated, checkable paperwork beats any clever line you could deliver at the roadside. A few of the questions that come up constantly. Can you refuse to let officers count the cash? Practically speaking, no. The search powers exist, and obstructing an officer creates its own separate problem. What you can do is ask which power is being used, ask for the grounds, and make sure the amount is recorded accurately, because a disputed figure becomes a miserable thing to argue over later. What if it wasn't your money? Say it belonged to your mother. Then she can apply for its return too. Section 301 concerns who the cash belongs to, not who happened to be carrying it. If money is being transported on someone else's behalf, that person's documentation matters just as much as yours. Do you need a solicitor? Yes, and early. This is a specialist field. The deadlines are short, and the hearings are civil rather than criminal in nature. Don't wait to see how things unfold. By the time a 6-month order is granted, the shape of the argument has usually already been set. Should you simply stop carrying cash altogether? No, that's not the takeaway, and it's not the kind of country worth living in. The lesson is that if you're moving a meaningful sum, carry the story behind it too. A screenshot of the withdrawal, the receipt, the invoice, 60 seconds of preparation that could save you months of trouble. What if an officer offers to hand it straight back if you just explain it there and then? Politely say you'll account for it properly in writing, and ask for that offer to be logged. Verbal assurances at the roadside aren't court orders, and the person making the offer usually isn't the person who ends up deciding your case. How much does getting it back typically cost? That depends entirely on the sum involved and how complicated the case is, so there's no single figure worth quoting. But don't assume it's out of reach before you've even asked. Call a firm that handles this kind of work and ask what the first step costs. That initial call is usually free. So to sum it up, £1,000 is the trigger point, and checks, drafts, and betting slips all count as cash under the law. The 48-hour clock excludes weekends and bank holidays. Cash can be held for up to 2 years without anyone ever being charged, and it's you who has to apply to get it back. And if you're ever standing at the roadside, one sentence: it's mine, it's lawful, and I'll account for it in writing. If this has already happened to you, don't sit on it. Request the footage and the record of your stop. Instruct a solicitor who handles this area of law, and start pulling together the paperwork. The clock here is not on your side. Subscribe so you know all of this before you ever need it, rather than after. Know your rights, say less at the roadside, and let the paperwork do the talking. See you in the next one.